Good afternoon, and welcome to the Dole Institute of Politics. My name is Emily Depew, and I am a member of the Dole Institute's Student Advisory Board, the official student group of the Institute. The Student Advisory Board is a bipartisan group whose members can access many great opportunities through their involvement. If you are a student and would like to join, please contact us by emailing dolesab@ku.edu. After the presentation, we will have time for some questions. If you have a question, please raise your hand and a student worker with a microphone will come to you. Please stand if you are able and ask just one brief question. If you have difficulty hearing during the program, please alert one of our staff members or student volunteers who will assist you. Before we begin, I'd like to remind you to please turn off your cell phones. Now please join me in welcoming the Associate Director of the Dole Institute of Politics, Audrey Coleman.
Good afternoon, everyone. Thank you so much for joining us this afternoon at the Dole Institute. As Emily said, I'm Audrey Coleman. I'm Associate Director here, and we're so pleased to have Michael Bobelian with us again this afternoon. It's been a little over a year since we last hosted Michael. He's an author and journalist who's spent some time doing research in our own archives for his book that was published in 2009. I wrote that down to make sure. Children of Armenia, A Forgotten Genocide and the Century-Long Struggle for Justice, which is the seminal work on the aftermath of the Armenian genocide and the U.S. response to it. But this afternoon, he's here to talk to us about his most recent book that was published this last spring, Battle for the Marble Palace, Abe Fortas, Earl Warren, Lyndon Johnson, Richard Nixon, and the Forging of the Modern Supreme Court. Palace uncovers the origins of the messy confirmation fights that the nation has endured in recent years. And I should have mentioned, Michael has also been published online at Forbes.com, published in the Los Angeles Times, Washington Monthly, written for Reuters, and the New York Law Journal, among others. And there will be a book sale and signing with Michael after this program. Ladies and gentlemen, please join me in welcoming Michael Bobelian.
Thank you, everyone, for being here, and I want to thank the Dole Institute and Audrey in particular for inviting me here. I was here last February on a completely different subject and really admire the work that's done here and the importance of chronicling Senator Dole's life and providing such hardy research material for future generations, and it's something that's very necessary, especially speaking as someone who's gone through many archives before. So I really enjoyed my time here, and like I said, it's a great place. And so today, I want to talk a little bit about my book. And you know, on the surface, it's about the Supreme Court, but it's not really about the court. It's about the political battles surrounding the court from the 1950s through the early 70s. So that means I will not torment you both in the book and in today's lecture with talks of judicial precedents or theories of constitutional interpretation, and the worst torment of all, those Latin terms that my law professors threw at me a long time ago. But before going to that era, I want to begin the story in 2016 when Justice Antonin Scalia died unexpectedly. And at the time, everyone assumed that Barack Obama would appoint his successor, and for the first time in decades, the court's makeup would go from a 5-4 conservative majority to a 5-4 liberal majority. But of course, that's not what happened, right? Senate Majority Leader Mitch McConnell came up with what people thought was a very novel argument. He said Obama was a lame duck because he was in his last year in office, and that a new president after the election should be able to pick Scalia's successor. Now, I remember at the time reading a lot of headlines that used the word unprecedented to describe what McConnell had done. And the same headlines were used about a year later when Donald Trump nominated Neil Gorsuch, because Gorsuch was the target of a filibuster. And then, of course, who can forget the combative exchange between Brett Kavanaugh and the Senate Judiciary Committee last year. Now, the thing is, all of these types of events took place in 1968 in what was the most monumental and consequential confirmation fight in the nation's history. Now I want to take you back to that era and explain how that battle came about. These days, we have almost a granular analysis of the justices and where they stand ideologically. There's this thing that political scientists have developed called the Martin Quinn scores, and they'll tell you on every issue, First Amendment, Second Amendment, Civil Rights, Fifth Amendment, where does an individual justice stand in terms of the conservative liberal ideological spectrum. But no one thought of the court that way back in the 1960s. Yes, presidents did look at the potential ideology of a justice, but not, like I said, with the kind of modern-day lens that we do now. And Lyndon Johnson was the first president to use that modern lens as a president. And the way you could tell that is by looking at his immediate predecessors. So Harry Truman was president in the late 40s, early 50s, and he got to pick 4 justices to the Supreme Court. And they all turned out to be mediocrities who had very little impact on the court. And even more ironically, from a modern-day perspective, he was a Democrat, and they were all centrist to slightly right of center. Then we get, and before I get to Eisenhower, and Truman came to regret these picks. And with one of them in particular, and I'm not going to name names, but you'll figure it out if you read the book, he said, it's a nice guy, he's a really nice guy, but he's such a dumb son of a bitch. So Truman came to regret his picks, and so did Eisenhower. Eisenhower was president for 8 years, a Republican, and he got to pick 5 people on the court. And think about that. Look how influential he could have been, right? Because Clinton got 2 picks, Obama got 2 picks, Bush 2 got 2 picks, and now Donald Trump's had 2 picks. He had 5. Really, no modern president has had that opportunity, but only 2 of the 5 became reliable conservatives. The other 2, Earl Warren, the Chief Justice, and William Brennan, were the liberal titans of the court. So Eisenhower also came to regret his picks, and he said the picking Brennan and Warren were the biggest regrets of his presidency, the biggest mistakes of his presidency. And then we get to JFK, and he appointed 2 justices. One of them only served for 3 years, and one of them, Byron White, again, a centrist, sometimes right of center, sometimes left of center. Once again, looking at it from a modern-day perspective, you'd say, what in the world were these presidents thinking? Why were they so bad at selecting nominees that didn't match their ideology? And that's where LBJ really comes in, because he was the first person to really look at ideology in a close way. Now, you get to LBJ in 1965. He's at the height of his powers. He's just won re-election by a landslide. And he's passing all these bills through Congress, to what came to be known as the Great Society. That's Civil Rights bills, Voting Rights Act, Medicare, Medicaid, many environmental bills, consumer protection laws, etc. And he wanted to make sure that the Supreme Court would support this legislative agenda, because most of these bills, just as the Affordable Care Act was in recent years, would get tested in the courts. And he had remembered what happened to Franklin Roosevelt in the early years of the New Deal, when the Supreme Court kept striking down New Deal legislation. So he wanted to make sure that his legislative achievements would be protected. He also wanted to make sure that there were justices on the court that would perpetuate the liberal legacy that Earl Warren had started. And finally, LBJ, being the Machiavellian that he was, he kind of wanted a spy on the court, someone who could tell him what the inner workings of the court were. But he had one problem. There were no openings. Now, most presidents would simply wait for a retirement or perhaps someone dying, but LBJ wasn't like most presidents. So he used his powers of persuasion to create an opening. And I'm going to read an excerpt from the book now about what came to be known as the Johnson treatment. Unyielding to the end, Johnson chipped away at anyone's defenses until they crumbled. It's what helped him become a legislative puppet master. It's also what drove his subordinates to tears and his colleagues into submission. A notorious manipulator, Johnson fluffed one man's ego while crushing another's to get his way. If all else failed, he typically resorted to an in-your-face style. The Johnson treatment often began with him grabbing someone by the lapels or arms, and while his 6'4" frame towered over a shorter man, Johnson poked his target with his hands or jabbed his head in a rooster-like motion, invading the man's personal space like a boxer cornering an opponent in the ring. Out of his mouth spewed the most convincing arguments, a slew of policy justifications, statistics, moral persuasions, whatever was needed. Johnson wasn't a fast talker, and he was an unexceptional public orator, but in these private sessions, he spoke almost without pausing. Hubert Humphrey, who was his vice president, described being on the receiving end of the Johnson treatment, and this is his quote, "It was an almost hypnotic experience. I came out of that session covered with blood, sweat, tears, spit, and sperm." So Johnson unleashed this treatment on Arthur Goldberg, who had been appointed in 1962. And he convinced Goldberg to resign from the court and become the UN ambassador. Now, the UN ambassadorship is an important job, but it's nothing compared to a job on the Supreme Court, right? Especially for a lawyer, that's the pinnacle of your career, and you have lifetime tenure. But Johnson convinced Goldberg, he said, look, when you're in the UN, you're going to be my second Secretary of State. You're going to lead my policy in Vietnam. You're going to bring peace to Asia. And when I run for re-election in 1968, I'm going to consider you as my vice presidential pick. These were all lies. None of this came to fruition. Goldberg ended up resigning from the UN in 1968, very disappointed. But within 4 days of Johnson unleashing his treatment on Goldberg, Goldberg resigned. So now Johnson had his opening, and he had the perfect person to fill the spot, and that was Abe Fortas. Now, Fortas and Johnson went way back. Fortas was his political advisor, his legal advisor. He was a close friend. He was a reliable liberal, just as Johnson had wanted. He knew Fortas would uphold his legislative accomplishments, just as he wanted. And Fortas was known as a brilliant lawyer. His friend called him a brain surgeon, the person you called in when all else failed. And if there are any lawyers in the room, there's a saying among lawyers, when someone is a really good attorney, we call them a lawyer's lawyer. But Fortas was so good that they called him a lawyer's lawyer's lawyer. So Johnson nominates Fortas, and he's quickly confirmed in 2 weeks through a voice vote. Now, a voice vote is, normally there's a roll call vote where every senator's name is called alphabetically and they say yay or nay. But a voice vote is far more informal, where the whole Senate just says all in favor, say yay, all opposed, say nay. So Fortas was confirmed in 2 weeks through a voice vote. That's in 1965. Now let's fast forward to 1968 and the center of the story. Earl Warren was still Chief Justice, and he was arguably the most consequential Chief Justice of the 20th century. And he knew how important his legacy was. He knew how much he had accomplished through the court. And in June of that year, Robert Kennedy was assassinated. And once that took place, Warren decided to resign because he felt that Richard Nixon was likely to win the presidency. And he was right. Months later, Nixon was elected president. Now, Warren hated Nixon. He hated him personally. He hated him politically and ideologically. In fact, Warren's son said, all the way to the end, my father detested Nixon with an abiding passion. So he timed his resignation so that LBJ and not Nixon would pick his successor. And this was in June of 1968. And LBJ decided to appoint Abe Fortas, who had already been an associate justice, to now become Chief Justice. And he would have to get confirmed again to become Chief Justice. And everyone thought in Washington that this was going to be a shoo-in for Fortas, because he had the Senate liberals behind him. And then LBJ went and lobbied the two leaders of the potential opposition. One was Richard Russell, the Georgia senator who was the head of the Southern Democrats. Now, he and LBJ saw eye to eye on almost nothing, especially civil rights. But they were close friends. LBJ was sort of a surrogate son to Russell from his days in the Senate. And so he got Russell to support Fortas. And then he went to Everett Dirksen, then the Senate Minority Leader, the leading Republican in the Senate. And again, you'd wonder, especially looking at the political lens from 2019, why in the world would Dirksen support LBJ? But he did. They were close friends. He had supported LBJ throughout the 1960s on important legislation like the '64 Civil Rights Act. And they spent a lot of time socializing together. It'd be sort of like Trump and Chuck Schumer hanging out at Mar-a-Lago. But politics was different then. It was much more friendly and civilized, if you will. So he got Dirksen to support him, and he got Russell to support him, and there really wasn't much opposition left. And everyone assumed that this would be an easy victory. If you read the editorials from the time, all the leading newspapers, the television news are all assuming that Fortas will become Chief Justice. In the archives, there are countless letters written to Fortas congratulating him right after he's nominated in late June of '68. And these letters are from justices and politicians and corporate executives and deans of law schools, pretty savvy people. And history also pointed to a swift ascension. From 1894 to 1967, only 1 out of 46 nominations to the Supreme Court had been rejected. Most people were confirmed in days, not weeks or months. The hearings were often very short. One of them lasted just 5 minutes. There were no background checks, no litmus tests, nothing of that sort. And 2/3 of these nominees were confirmed through a voice vote, which I described earlier, including Abe Fortas, who, as I said, was confirmed in 2 weeks after only 3 hours of hearings. But what everyone underestimated was the ferocity of the opposition he would face. And South Carolina Senator Strom Thurmond emerged as the front man of a coalition of senators willing to breach the deep-seated customs governing judicial appointments to sabotage Fortas. Now, they did this not because they despised Fortas, but they did this as revenge against the Warren Court. And frustrated by their repeated failures to neutralize the Warren Court over a span of 14 years, Thurmond and his allies devised a strategy which now seems very easy to understand, but was really revolutionary at the time. And that was obstruct your political rivals' attempts to appoint justices to the court and stack the court with people who agree with your ideology. So again, that's what was done in 2016. That's what Democrats tried to do against Neil Gorsuch in 2017. But that just, no one thought of the court that way. And certainly the Senate didn't think of its role in the confirmation process until 1968. So what did they do? What were some of these revolutionary tactics? And some of these will sound familiar now. First thing they said was LBJ was a lame duck. He had about 6 months left in office, and they said the next president should name Earl Warren's successor. Then they accused Abe Fortas of being LBJ's crony. They said he was way too close to Johnson. And in this case, they were right. Their relationship, which was very close prior to Abe Fortas becoming an associate justice, continued in the 3 years that he was an associate justice up to his nomination as chief justice. They met in person 80 times during those 3 years. And Fortas actually attended more cabinet meetings than Arthur Goldberg, the man who had been appointed to the UN. And he helped with speeches. He helped LBJ deal with crises. He helped with legal strategy. At one point, a senator had called the White House on a legislation and was told by an operator, the president is away, but Mr. Justice Fortas is here, and he's managing the bill for the White House. So from modern-day standards, it was a very close relationship and something we would find unethical, but at the same time, it was something that was commonly done in the nation's history, dating all the way back to George Washington, Abraham Lincoln, and FDR. He used to play poker with Justice William Douglas, whom he almost made his vice president in 1944. Harry Truman and Chief Justice Vinson would regularly go sailing on the presidential yacht. So this was a type of relationship that had existed regularly in the nation's history, but sort of like a nanny gate in the 1990s. You remember with Zoe Baird, the person who Bill Clinton tried to nominate to become Attorney General? The ethical norms operating in Washington were shifting under Fortas's feet, and he was kind of caught in this earthquake. So lame duck, crony, but they didn't stop there. They went after an issue that's far more juicy, scintillating, if you will, and something that really caught the public's attention, and that was pornography. That was a big culture war issue of the day in the 1960s, because you have this cultural clash. Playboy magazine was the second most subscribed magazine of the era. And Hugh Hefner, its publisher, had become a household name. At the same time, according to polls, 73% of Americans did not want adult materials in their neighborhoods. And the court was really stuck in the middle because they had to balance the First Amendment rights on one side and the community's right to prohibit these materials on the other side. And it was very unworkable constitutional doctrine that they had developed that eventually in the 1970s they abandoned altogether. But Thurman and his allies cared little for these nuances. They called a witness, two witnesses actually, and one of them was Charles Keating. His name might sound familiar. He was involved in the savings and loan scandals in the 1980s. But in the 1960s, he was the head of the leading anti-pornography group in America. And he and a colleague came and testified against Fortas, and they said the Supreme Court was responsible for the moral decay of the country, and that pornographers looked to the court as their champion, as their protector. And this really caught the White House off guard. So who did they send to kind of counteract this testimony? Warren Christopher, another familiar name. He was Bill Clinton's Secretary of State. At the time, he was the Deputy Attorney General, the number 2 job in the Department of Justice. And he testified to the Judiciary Committee, and he tried to explain some of these constitutional nuances that I said it was very difficult for the court to balance these rights. But Thurman wasn't really interested in those nuances. So imagine this scene. Here's Warren Christopher sitting at his desk testifying, and the Senate Judiciary Committee, right, they sit slightly raised in a dais, and while he's testifying about these First Amendment issues, Strom Thurmond was flipping through a nude magazine. But Thurmond and his allies didn't stop there. He went to the Judiciary Committee and he said, why don't we watch some of these movies that the court is shielding from censors? They said, no, Strom, you're crazy. We're not going to do this. But he went ahead anyway. And there wasn't a real theater room that he could use, so he found a wood-paneled room in the Senate, and he got a coin-operated projector, and he put on one of these movies. And it started an avalanche. From about July of 1968 through September, there were 30 films in all that were watched in the Senate, and it came to be known as the Fortas Film Festival. Exactly, and Fortas got labeled Mr. Obscenity. And if you look at the polling data, it's what really hurt his candidacy within the public. Now, while all of this is going on in the Senate from late June through mid-September of 1968, there's an election going on, right, a presidential election. And Richard Nixon becomes the Republican candidate in August at the convention. And he was constantly bashing the court as part of his campaign strategy, usually over issues of law and order with Miranda and other such rulings. But here's what's so unusual. These days, we see presidential candidates tying their candidacy to the court in a very direct way. Donald Trump even went and put out a list of potential people that he would nominate. Again, this wasn't done in the 1960s. It wasn't done in the 1950s. It wasn't done in previous eras. Even FDR in 1936, who is in the middle of a feud with the Supreme Court. He's months away from launching his court packing attempt to pack the court. And he's in the middle of an election, and fellow Democrats urged FDR to campaign against the conservatives on the Supreme Court. But he refused. He said, I'm not going to make the court a campaign issue. But that changed in 1964 with Barry Goldwater, and it especially changed with Richard Nixon, 64 with Barry Goldwater and Nixon in 68. So Nixon becomes the first presidential candidate to tie his candidacy directly with the court. And he promised people that he's going to appoint what he called strict constructionists, we now call conservative justices. And this was something that caught even his own campaign advisors off guard. One of them said, it doesn't make me happy to say this, but he's attacking the Supreme Court because he's convinced that's what voters want. And that's exactly what happened. So now the court was getting politicized in the presidential election process for the first time. And how did this impact Fortas? Well, Fortas's opposition is growing, right? And Nixon is basically telling them, not explicitly, but implicitly, if you reject him and I'm elected, I'm going to pick a person that you will like. And Pat Buchanan, another familiar name, He worked on the Nixon campaign, and he wrote years later, privately, Nixon wanted the Fortas nomination killed, but he did not want our fingerprints on the murder weapon. So you have all of these forces directed at Fortas, and they culminate in a filibuster. Again, sounds familiar, right? So out of the 163 people nominations to the court up to that time, Fortas was the first person to be a target of a filibuster. And finally, people used Fortas for target practice for all the purported sins of the Warren Court. And his hearings lasted 11 days, and just to give you context, that's more than all the days of all 9 of FDR's nominations put together. So that's how much scrutiny he faced from the Judiciary Committee. And I'm going to end with reading you another passage. And again, it involves Strom Thurmond with Abe Fortas, which I believe it was on his 3rd day of testifying. Thurmond's angular nose and chin, high cheekbones and thick eyebrows endowed him with a hawk-like mien, and those narrow, piercing eyes zeroed in on Fortas as the senator began his final assault against the beleaguered justice. With so many notorious rulings at his disposal, Thurmond settled for Mallory v. United States, a 1957 case in which the court had freed a confessed rapist because police had held him too long prior to his arraignment. Predating Miranda, it was one of the court's earliest criminal procedure holdings to instigate widespread recriminations. "Why did he go free?" Thurmond screamed at Fortas, deviating from the script prepared by his staff. "A criminal, a convict, a guilty man who committed a serious rape on a lady in the city. Do you believe in that kind of justice?" he demanded. Through years of experience testifying before Congress, Fortas had relied upon his extemporaneous wit and sharp argumentative skills to take on some big foes. Never embarrassed, a New York Times reporter wrote of the poker-faced justice, never taken by surprise, he is the ultimate unflappable man. And so far, Fortas had remained unruffled by Thurmond's inquest, with the only sign of nervousness his occasional tendency to fiddle with a pitcher of water on his desk. But nothing in Fortas's background had prepared him for Thurmond's latest outburst. Justice Fortas again brought up the constitutional limitation inhibiting him from responding. The senator interjected with a crescendo. "Mallory, I want that word to ring in your ears. Mallory!" Thurmond bellowed, getting louder and angrier with every utterance of the assailant's name. "Mallory, a man who raped a woman, admitted his guilt, and the Supreme Court turned him loose on a technicality. Wasn't the decision," Thurmond shouted, "calculated to encourage people to commit rapes and serious crimes? Can you, as a justice of the Supreme Court, condone such a decision?" Flushed and visibly shaken for the first time, Fortas rested his head in his hands before glancing over to James Eastland for a lifeline. 3 years earlier, the chairman of the Judiciary Committee, Eastland, had helped Fortas, so much so that Fortas thanked him for his courtesy and understanding in overseeing his confirmation. But now, looking over a document, Eastland made no effort to rein in Thurmond. Isolated and helpless, and with a look of stunned disbelief on his face, the justice sat in angered and outraged silence for a few moments. Leaning towards the microphone, he appeared to be preparing to burst out with a snappy retort, but none ever came. No other confirmation hearing would contain such a remarkable exchange until Brett Kavanaugh. Thank you. I think we have time for questions, right? Yeah, she's going to bring a microphone.
Do you think that Fortas' Jewish background had anything to do with his ultimate or his rejection?
Yes, but it's difficult to quantify. So if you look at the materials in the archives for the Senate Judiciary Committee, they're mostly constituency mail, people sending in letters, and 80%, 90% of it is in opposition to Fortas, and most of those have a problem with the law and order rulings that I mentioned, and they often call them a communist, part of an international communist conspiracy, which was very big during the Cold War. And then there are quite a few that are anti-Semitic. Within the Senate, it's tough to gauge. The issue of anti-Semitism did come up. Jacob Javits, who was a senator from New York, who's Jewish, said it definitely exists and it might be there, but we shouldn't quickly smear people as an anti-Semite just because they oppose Fortas. We should find evidence for it. So it's definitely there, and there are a couple of statements made by senators, but it's in private, closed-door events, it's hearsay, so it's hard to quantify. And this is what I mean by that. If you look at the Southern Democrats who opposed Fortas, many of them gladly made what we would consider racist declarations in public, but they did not make anti-Semitic statements in public. So that's why it's hard for me to quantify. So it's definitely there, but how much of a role it played, it's hard for me to tell you. But I can say that considering there was so much contempt for Fortas and the Warren Court and its liberal jurisprudence, it was part of that. It was part, they had plenty of other reasons to oppose Fortas before it came to the issue of what religion he was. So it kind of fit into the overall opposition, but it's hard to disseminate or dissect exactly what role it played, other than to tell you that it played some role. I wish I could be more specific, but the evidence doesn't allow me to be more specific. Great question.
What do you think was the legacy, if at all, in the United States Senate in terms of political dynamics and political climate after the Fortas fiasco? And when it came 20 years later or so with the Bork nomination, was it payback time for the Democrats?
Right. Another great question. So what the Fortas nomination changed was the Senate was no longer, it refused to just rubber stamp these nominations. As I said, it had almost a cavalier process and very little scrutiny of justices prior to 1968. They were mostly confirmed through voice votes, and the hearings were incredibly short. I mean, these things you could read in 10 minutes, whereas the Fortas hearings go over 1,300 pages transcribed. So now the Senate was going to put every nominee under great scrutiny, and it was not going to be as deferential. Now, did that play out into a huge confirmation fight each time? No, it didn't. But if they had a nominee who they disliked, like Robert Bork, and they felt the president didn't have the support in the Senate, they would unleash all of the same kind of fury that Fortas faced. And now going to Bork specifically, in 1987, the roles were reversed. Strom Thurmond was his lead supporter in the Senate. Howard Baker, who was a senator in 1968, he was Ronald Reagan's chief of staff in 1987, he was sort of the point man in the White House fighting for Bork. So here you have Baker, who was one of the chief architects of the filibuster, and Strom Thurmond, who led the opposition against Fortas. Now they're on the other side, right? And people remembered. So there are quite a few speeches where they say, look, you guys are accusing us Democrats of using these unprecedented tactics, sort of things that seem unseemly against Bork, but you did the same thing against Fortas, and they took out excerpts of Thurmond's speeches and said, there you go, you told us to do this. Another example of that was Joe Califano. He was one of LBJ's domestic advisors, and he was intimately involved, again, in the White House while this was going on. He wrote an op-ed in 1987 urging senators who opposed Bork to filibuster him. So even though most people have forgotten about Fortas, and I would argue that it's his nomination fight that kind of set the stage for modern confirmation battles, people in 1987 certainly remembered, and they did see it as payback to some extent to go after Bork.
Yeah, I remember under Reagan, he had nominated Douglas Ginsburg, and then it come to find out, oh wow, he had tried marijuana when he was in college, and like if that was some really big whoop-de-doo deal. Okay, but it must have been. What I mean is, Reagan or somebody must have understood that he was going to have a rough time being confirmed, right? Or if they would have went ahead, would Ginsburg have gotten confirmed?
I don't know if he had gotten confirmed. I try to avoid hypotheticals because if you look at recent history, right, 2015, if you had asked people who's going to win the presidency, I don't think anyone would have picked Donald Trump, right? So I try to avoid prognosticating. But I think Ginsburg, they just didn't know. They didn't scrutinize his background enough. And if you look at what happens in '68 and then with Nixon's nominations, which are sort of the last fourth of my book, presidents make a lot of mistakes, but they set up the template for modern presidents in terms of how they look at ideology and how they look at the political considerations of a potential justice, right? But it took them many decades to perfect the process. And I think we've reached the point where they've come close to perfecting it. But even then, Brett Kavanaugh, I don't think the White House knew about the allegations, the sexual assault allegations that came out during his confirmation, right? So even today, when they're so much better at dealing with these types of things and kind of really going through a background check, they still overlook certain things. So I think with Douglas Ginsburg, they simply just missed it. But I think if they had known, Reagan would not have nominated him. I think he would have gone with a safer pick like Anthony Kennedy, who eventually was the nominee.
The response of Strom Thurmond in 1968 that you characterized for us, can you give us a little more sense of whether you saw that as very calculated? Was it in a kind of emotionality? Were there a lot of people behind Strom Thurmond kind of egging him on? What was the force that brought him to have the tactics that he did?
Right. Well, for this lecture's purpose, I've put him as sort of the point person, but he and another senator, not well known now, Robert Griffin, who was a first-term senator from Michigan, a Republican, led the fight against Fortas. Certainly Thurmond was far more emotional than Robert Griffin. Griffin looked at it as a question of senatorial power and what's the Senate's role in the confirmation process, and in part partisanship, because it's an election year, right, and he wanted a Republican to pick Earl Warren's successor. For Thurmond, it was a lot more emotional. Because he despised the Warren Court because of Brown v. Board and all the civil rights rulings. But they had a lot of support, certainly, because they put on a filibuster. And I'm not going to give you the end result because it's part of the drama of this, but they certainly had many senators supporting them. So these were not just isolated people, screaming out in the wilderness with no one hearing them. But a lot of what Thurmond was doing was pent-up fury directed at the Warren Court. And much of my book, sort of the central narrative is this confirmation fight, but much of my book looks at earlier attempts to attack the Warren Court. You have the massive resistance to integration in the South. That tries to thwart the court. But that's the one we kind of remember, right, with Little Rock and things like that. But there were many other examples. So when the court in 1962 started to create the one-person, one-vote legislative districting policy, that because back then one legislative district could have 1,000 people or 10,000 people, another one could have 1 million people. They were very unbalanced. And they said, no, every legislative district has to be equally proportioned. That created immense anger within the political ranks, because almost every legislative district in the country had to be rejiggered, had to be drawn up again. So people tried to pass constitutional amendments. Everett Dirksen, the person I mentioned, Senate Minority Leader, he tried to pass a constitutional amendment to undo the court's ruling. And that amendment was widely supported by many state people working in state governments as well as corporations. You look at the law and order rulings, that created a lot of backlash, right, like Miranda. And then really little known, in the mid-1950s, the court had put an end to McCarthyism. So McCarthyism kind of started in the late 40s, and at first the Supreme Court said, it's fine by us. You're not violating the Constitution. But starting in 1956 and capped off with 4 rulings in 1957 that critics came to call Red Monday, it kind of puts an excess to the excesses of McCarthyism. That created an immense backlash to the point where Congress was going to weaken the court's jurisdiction because Congress can determine what kind of cases the Supreme Court sees. There are only 3-4 types of cases that are actually outlined in the Constitution. So the House passed these measures overwhelmingly, these anti-court measures, and it came down to a massive fight in the Senate, and all the people involved in Fortas were involved in that fight. So LBJ was still a senator, and he was the chief defender of the court back in 1958, and Thurman and McClellan, all these Southern Democrats were attacking the Warren Court. And that's an issue that no one's ever heard of. It's a big chapter in my book. So by 1968, Thurman realizes, wait a minute, we tried to pass legislation. We tried massive resistance to integration. We tried to pass constitutional amendments. They're just too difficult to implement for whatever reason, right? So the way to control the court is to control its membership. So that's sort of the light bulb moment that takes place. And it's not just him, Sam Ervin, another senator, and others come to this realization that if you're going to control the court, you can't do it in these other ways that we tried. We tried and failed, and they really tried hard. But they fell short, sometimes by only a single vote. So they come to this realization that the way to control the court is to control its membership. And that's when they unleash all of these new tactics that no one had ever seen because they want to control the court. And that's what I meant by they're not really targeting Fortas. They're targeting the Warren Court. And they're trying to control the court. And Fortas was a proxy for Earl Warren because he was a similar ideology. So he kind of is the victim, if you will, the collateral damage of this new way of seeing the court and of trying to control the court. So it's a long answer to your question, but that's how it played out.
I'm kind of shocked by what you're saying, I guess. I lived kind of in a bubble, and I thought the court was free from this stuff, but apparently I was in a bubble. And so I'm bothered by having this politicization going on, and I wondered if anywhere you have some thoughts on how to deconstruct the situation.
Right. How to reform, perhaps? All right, so you know who gets most upset at me are lawyers. Because when I say the court is politicized, they're like, no, it's apolitical. I said, where are you from? Like, it's very politicized. Part of that is because of the way we've structured our Constitution. We allow our Supreme Court to make decisions that most other democracies do not allow their highest courts to make. So our Supreme Court is the most consequential judicial body in the world because of that. Okay, so part of it is if you're going to give 9 people this authority, they're going to use it, right? So that's far harder to reform. I think the parts you can reform is now what LBJ and Nixon kind of started by looking at the ideology of the justices has now been brought to the point of near perfection. And I think that's the danger, where now if someone is appointed by a Republican, they basically act as a Republican. If someone's appointed by a Democrat, they act as a Democrat on the court. And that's the dangerous part. I wish presidents would appoint more centrists. Certainly, I would expect the Republican to appoint a conservative, but someone not too conservative, more of a centrist conservative, and likewise with the Democrat, more of a centrist liberal. Then I think you'd have less polarization. But that's not the direction it's going. It's going to the extremes. And if you look at, like I said, there are these ways of analyzing the justices' ideology. 9 out of the 10 most conservative justices in U.S. history were appointed in the last 40 years. And likewise, I think 8 of the 10 most liberal were appointed in the last 50 years. So there's something going on, right, where they're becoming more liberal on one side and more conservative. And I think that is where you could have reform. And the only way you could do that is if the Senate acted as a singular institution rather than as 2 political parties. Where if they told a conservative or Republican president, you get to pick a conservative, but like I said, more of a centrist conservative, and they told the Democratic president, we will confirm a centrist liberal, but not an extreme liberal or not an extreme conservative, then I think you could have the kind of reform that I would envision. But the odds of that happening in this political environment are, fantasy, right? So for the foreseeable future, I don't see any change. I think it will get worse. And if you look at the last 3 years, they kind of tell you how bad it's gotten. Obama picked Merrick Garland, who was a liberal, but not very liberal. He was more of a centrist than other people he could have picked. And he was 63 years old. And I think he picked someone who's older rather than someone in his 40s or 50s to say, this guy's not going to serve 30 some odd years. He's probably going to serve, 15 years, 20 years, something like that. And I think that was a way to kind of say, will this make the Republicans in the Senate, will Garland be more palatable because of these characteristics? And ultimately they said no to that. And then, there's a very slim Republican majority, but Donald Trump has picked people who are very conservative. Even though there's a slim Republican majority, you figure maybe he would have picked people who are more centrist. So it just hasn't functioned that way. Like, they've had their opportunities in their last 3 years to pick people and to confirm people who are more in the center, but both sides have kind of rejected that. So I don't see any kind of reform or reduction of this politicization in the foreseeable future. I think it'll probably stay the same or get worse. What?
I'm kind of picking up what you were saying, but I'm just curious, do you see any pros or cons with all the Federalist people being appointed to the Supreme Court? Do you see any way in which some of the judges could surprise the current president?
Sure, and it still happens. I think Chief Justice John Roberts surprised people with the vote on the Affordable Care Act, right? But it happens less and less. Like, again, there are people who measure these things at the granular level, and you could see it happening less and less than it used to, let's say, in the 80s and the 70s, where they would have a much more ideological separation from the president who appointed them. And that's a danger, because if we're going to allow 9 people to have this kind of authority and they're not democratically elected, then they shouldn't act in such a partisan and deeply ideological way, right? Because otherwise then they're just politicians wearing robes. And that's not how the Founding Fathers or anyone really envisioned the Supreme Court to operate. And look, 99% of cases, they would rule 9-0 unanimously, all right? Because most cases, it's pretty obvious what the answer is, but those aren't the cases we care about as a society, right? There are 10, 15 cases a year that are really politicized, and really a handful a year that are very politicized. And those are the ones we care about, and those almost always fall 5-4, 6-3, sometimes 6-3, but often 5-4. And if you look at the Bush v. Gore, right, that was 5-4, and every Republican voted one way, every Democrat, liberal voted another way. You can't get more partisan than that, right? And that kind of undermines the court's credibility when it acts in that way. So that's the negative consequence that we're dealing with. And then you have to wonder, like I said, if they're going to be that partisan and that ideologically driven, with very few exceptions, and there are some, but very few, then why are we giving them all this authority if they're not democratically elected? You see, so then you get into a bigger philosophical issue of what the court means and what its role is in our constitutional system. And I think it's heading into dangerous waters in doing that. I think Chief Justice Roberts is very aware of this, and I think you will see him become more of a centrist who's kind of rotating between the liberal and conservative camp in the court, because I think he recognizes, more than the other justices, the dangers to the court of being so partisan and being so ideological. So he might stray more than he has in the past from his conservative roots and his Republican appointment, but most of the others, they rarely stray. So.
In your studies, have you seen any discussion of life terms and whether or not a modification of that might be in order?
Right. So one of the ways they tried to neutralize the Warren Court, its critics, was to end lifetime tenure. And they came up with 8-year terms, 10-year terms, 15-year terms. You'd have to amend the Constitution. That's a very high mark. So it never happened. As I said, these were the efforts to neutralize the Warren Court. Back when lifetime tenure was decided upon by the Founding Fathers, life expectancy was a lot lower, right? People didn't serve. No one expected anyone to serve 30-plus years on the court. And now that's, 25 years is quite common now, and 30 years is becoming more and more common. So I think that's having a term of 15 years or 20 years is a safe way of reducing sort of the stakes involved with these nomination fights, because you kind of say, okay, we're not going to have to live with this person for forever, right? We're going to, he or she's only going to be there for 15 years. But again, you'd have to amend the Constitution, and in today's political environment, getting all those states and both houses of Congress to agree to such a thing, probably not going to happen. So, but I think that, like I said, that's a safe way. There are more politically dangerous ways that people have thought about, like, packing the court, adding new slots on the court and appointing them with Democrats or conservatives, right? So to me, those are very politically dangerous. I think creating a shorter tenure where the justices still have independence, but they're not there for, decades and decades, is a safe way of kind of depoliticizing the court a little bit. But I just don't see it happening in the near future. All right, well, thank you very much, everyone.